Hello, everyone. My name is Miran Fardis. I'm an immigration attorney based in San Diego, California, serving all 50 states and actually the entire world. Immigration is federal law, so we serve everyone who needs help in this area of law. I'm passionate about immigration. I'm an immigrant myself, and I'm always looking forward to hear challenges, find stories, and work through their issues and find solutions. So today we're going to do a quick follow-up on a video we did just a few weeks ago about the 90-day rule. So I had some questions about what that rule is and where does it come from. So there are some rules that are USCIS rules, meaning they're codes, statute mandated by Congress. There's some rules that are written by the Department of Homeland Security itself. There's some rules that are written by the Office of President. So rules are different. Now, this rule in specific comes from the State Department. So State Department in 2017 enacted a rule called the 90-day rule, and it was based off of Immigration and Naturalization Act 212A6CI. So this really was a framework for the State Department to understand the intent of a visa applicant. So if somebody goes to a U.S. consulate embassy, asks for a B visitor visa, or ask for a student visa. This is a guideline, a directive for State Department to understand, is this person really going to US to do what they're saying what they're going to do, or do they have a different intent in mind? So this structure is from the State Department directive. In 2018, USCIS adopted this rule. They adopted this rule, and it was under the chapter Chapter 3, Volume 8, Part J of the Policy Manual of May 5th of 2018. That's how USCIS adopted this policy from State Department, and it was in the Foreign Affairs Manual 9 FAM 302.9-4B3. This is the State Department's manual. USCIS adopted this in 2018. I must say that USCIS dropped this rule in December of 2021. It seemed to have created some confusion inside the US where the 90-day precise number would come into play. So now USCIS uses a term called a reasonable test. They don't really use the 90-day rule, they call it the reasonable test. But the idea is still there. It's the same rule. If you come into US and you tell the officer when you come into US, I have one intent to go into US. That intent is to be a tourist, or that intent is to be some type of employee. And you come into US and immediately after arriving, you change your status. You go and file for a different type of status inside US. It signals that you have misrepresented your intent before you were coming to US. This is what this rule really is about. It's a framework for USCIS, for State Department to know if you really are doing what you're saying you're going to do, or if you plan to do something else. It is always important to know that this is not really legal advice pertaining to your case. I'm speaking generally and broadly. Everyone's case is different. Your case is different than the next person after you. We always have to look at the facts of your case and see what applies. None of these are hard and fast rules. You may come into US and a week later you apply for adjustment of status, you got married to somebody, and your situation is very unique. You're able to explain to the USCIS officer at your interview why this happened, why within a week of arrival into US, you change your status. You requested to change your status, and the officer may accept your explanations. But it is important to know that this rule, this window, is basically a framework for the officer to know what your intent was at the time of entry, and if you actually misrepresented yourself or not. This is really what the 90-day rule is about. I wanted to clarify and explain the codes and the idea behind it. Hope this was helpful. If you have any questions, contact us. Like this video if you did. Like it and share it with your friends. Looking forward to speaking with you very soon.